First question is, what exactly is elder care or long-term planning, I should say?
So elder law is a subset of estate planning, and whereas estate planning attorneys focus on disposition of assets after death using mostly last wills and testaments or revocable living trusts, we take that one step further and we ask the question, what happens if we live a long time with a long-term care need? And a long-term care need is maybe a dementia or Parkinson's, multiple sclerosis, something that requires convalescent care. And as we all know, this type of care is incredibly expensive, and most people would be impoverished if they had to succumb to this type of care and privately pay the rest of their lives.
How do they avoid doing that?
Well, they have to hire us, or they hire another certified elder law attorney. But we do it through a number of strategies and methods, depending upon how much money they have to protect, how much time, we bring their income into it. So we do a full-blown audit of their financial lives, and we determine what strategy makes the most sense. In New Jersey and a lot of states, we use irrevocable trusts. We could use life estates. Sometimes we transfer to adult children, so long as they're financially sound and don't have marital difficulties. So there are a bunch of strategies. We also find that human beings by nature aren't planners. Mm-hmm. And so we end up doing a lot of crisis strategy planning for people. And that very often entails very intricate financial strategies in order to qualify people for Medicaid earlier.
So let me ask you this: who is you mentioned the federal government program Medicaid? Who specifically is that for?
So that's a really interesting question, because Medicaid is designed to take care of poor people. But the unfortunate truth is that even people who have saved money their entire lives, and let's say, for instance, the average individual who has a long-term care need may be in their late 70s, early 80s. So they've been retired for 15 years. And if they didn't have a long-term care need, financially, they'd be sound, and they'd be able to live the rest of their lives and perhaps provide a legacy to their children. But those type of people, when confronted with a long-term care need at $10,000, $12,000, even $15,000 a month, very quickly become impoverished. So Medicaid ends up being, even for people who have money and have never lived as a poor individual, Medicaid ends up being a backstop for them.
Is Medicaid federal, state, or is it county run?
So Medicaid is really a hybrid of the three. It is a federal program. It is administered by the states. The states have a certain amount of leeway. And then at a county level, that is where individuals qualify for Medicaid. And the county provides caseworkers who will audit the finances, 5 years of financial records of the applicants. So it's a federal program that is state run, but administered at a county level.
Okay. And a reminder to look at the camera. What is the criteria to qualify for Medicaid?
So there are two real buckets that we look at when we're talking about Medicaid qualification. First bucket is the single individual. That is the easiest one to describe, but actually the one with fewer strategies available. And a single individual can have no more than $2,000, and they must be clinically eligible for Medicaid, meaning they're of nursing home level care. What is nursing home level care? It means that they need assistance with at least 3 activities of daily living. And those activities are walking, bathing, dressing, toileting, transferring, and feeding oneself. A married couple gets a lot more complicated, but as I said before, there are more strategies available to a married couple. So in that case, the spouse that is applying for Medicaid can have no more than $2,000, but the well spouse, or what we call the community spouse, can keep up to $130,000. But the rule is a little bit less clear than that. They can keep 1/2 of the marital assets up to $130,000. So as an example, if a married couple has $500,000, when the applicant goes into an institution, for instance, the spouse can keep 1/2 up to 130. So even though it's 500,000, they can only keep 130. If, on the other hand, when that individual goes into an institution or facility, the married couple has, let's say, $200,000, the community spouse can only keep $100,000. Okay, so and then there are multiple other eligibility factors, which I think you'd have to talk to us in person to really get through all of those.
Okay. What if my loved one has too much income for Medicaid? Is that a thing?
That is a thing. So historically, Medicaid, especially New Jersey, let's talk about New Jersey. Historically, New Jersey had what's known as an income cap. In today's dollars, if an individual had more than $2,382 a month in income, they could not receive Medicaid at home. They could not receive Medicaid in assisted living. They could only receive Medicaid in a skilled nursing facility. But now New Jersey follows federal guidelines, and the state allows individuals to avail themselves of something known as a qualified income trust, or otherwise known as a Miller Trust, which allows individuals to qualify with more than $2,382 a month in income. However, that being said, even though there sort of isn't an income cap anymore, when an individual's income exceeds the private pay rate of either assisted living if they're there or skilled nursing if they are there, then the individual would not qualify for Medicaid. So it's a lot of money. Usually people don't try to qualify with that, but it does happen.
Sorry, what is QIT?
A QIT is a qualified income trust.
Okay.
And it is a trust that we recommend that the applicant set that trust up through their trustee in the month prior to qualifying for Medicaid. And any income source that is above the $2,382 a month must be placed in that qualified income trust and then used for certain purposes, mostly healthcare premiums or a copay, or what we call a cost share to the facility.
Can a loved one get Medicaid at home, or do they have to be in a facility?
So fortunately, individuals can receive Medicaid at home. And as you are probably aware, most people want to stay at home for as long as possible. The only downside to Medicaid at home is that it provides for 40 hours, up to 40 hours a week of care. So that's 5 to 6 hours a day. And as I said before, in order to be clinically eligible for Medicaid, one must be of nursing home level care. So very often when someone's of nursing home level care and they have no money left, it's very difficult for them to survive and thrive on 5 to 6 hours a day. But we do have plenty of clients who are maybe suffering from dementia and they're not all that active, and maybe they have family members who are helping out. And so Medicaid at home is a godsend to people like that.
So Medicaid, you can get Medicaid also in an assisted living facility then, it sounds like? Talk a little bit about that.
Right. So that's where many of our clients receive Medicaid. And I will say, before I describe assisted living Medicaid, skilled nursing Medicaid is the easiest Medicaid to get because skilled nursing facilities have more availability. Assisted living facilities get a little tricky because under state guidelines, they are only required to have 10% of their beds reserved for Medicaid. And so, for instance, in an 80-bed facility, that's only 8 beds. So as you can imagine, those are always full. So most assisted living facilities, I'd say 90% of the assisted living facilities in New Jersey require what's called a 2-year or a 3-year private pay period. They will not open a bed up for somebody for 2 years or 3 years, which whatever their contract says or negotiated by the family. But sometimes it's a little bit misleading. The families very often think that after 2 years, their loved one will automatically get Medicaid. First of all, they have to apply for Medicaid. And secondly, there still must be a bed available. So even though they've gone through their 2-year private pay period, there is often a waiting list. Mm-hmm. So what ends up happening very often without the proper guidance is that families wait the 2 years, and if their loved one runs out of money, then they notify the assisted living facility, my loved one's out of money, you said that she could get Medicaid after 2 years, and then the assisted living facility replies, she has to get on the waiting list now. So now the family has to private pay during that time period. It's very confusing for them, and another reason to seek guidance early in the process as your family is aging. But we apply for Medicaid at some point, and Medicaid will pay for everything at the facility minus the cost share, which is income. If it's a single individual, all that individual's income goes to the facility as a cost share. If they're a married couple, some of that income very often can go to the community spouse. Got it.
What's penalty?
So penalty is a very interesting
and sorry, quick construct. Reminder. That's okay. Start over, please. You repeated the question and the answer, which is good. A penalty is just a reminder to look at the camera.
Oh, okay. So the penalty is an interesting construct, and it was created in order to prevent individuals from giving money away in order to qualify for Medicaid. So what Medicaid does in New Jersey, there's one penalty divisor. So what they do is they take the amount of money that was given away with no explanation. Okay, so the presumption is if there's money that was transferred to somebody else, or checks written to cash, or ATM withdrawals, the presumption is that that money was given away in order to qualify for Medicaid earlier. And the applicant, through the applicant's family usually, must rebut that presumption. If they cannot rebut that presumption, Medicaid takes that number and divides it by a penalty divisor. The answer to that equation is, in a number of days usually, or months, how much time Medicaid will not pay for that individual's care, even though they're otherwise qualified. So if I may give an example, the penalty divisor in today in 2021 yep. is $10,700, which is the monthly divisor. It's broken down by day. It's $356 a day. So if an individual gave away $10,700 and had no explanation for why it was given away, they would divide, the state would divide that by $10,700, which is the divisor. Mm-hmm. And the answer is 1. That is the number of months that Medicaid will not pay for the individual when they are otherwise eligible.
Okay.
Okay. And we can use that penalty to our advantage sometimes if somebody is in a lower cost environment. So the $10,700 represents the average monthly cost of nursing home care. If somebody is at home or in assisted living and their cost of care is less than $10,700, we can sometimes advise to give money to the family and take the penalty at a lower rate. It's something that it's a little confusing to describe, but families come to us and we explain to them how they do that.
Let me ask you this, and you sort of touched on this, but I want to have it in one concise or one answer specifically in and of itself. What does Medicaid consider penalties?
Medicaid considers penalties any withdrawal that is not explained, that is not for, or let me say that a penalty is money that is used for any purpose other than for the individual applying for Medicaid. So some people think that giving gifts to children under that $15,000 per person per year rule for gift tax purposes is fine. Medicaid says that's a penalizable transfer. Paying for a grandchild's college education, penalty. Buying a car for another individual, penalty. But paying for a trip for yourself, that's fine. Paying for your own education, that's fine. Paying for your own car, that's fine.
Okay. What if you have a loved one who is going to experience a period of time that Medicaid won't cover them, what should that loved one's families be doing, or what should that loved one's family be doing, and then what should that person, him or herself, be doing as well?
So if an individual is in a situation where maybe they've given away money or they can't explain money that's been spent, and now Medicaid will not cover them, that they're in a tough position. Normally, either a family member has to take that individual in and care for them themselves, or negotiate with the facility, explain to the facility that we got ourselves into a bind, but mom, for instance, will be receiving Medicaid after X number of months. So we promise that she is going to have a source of payment. And so it's a negotiation at that point. But that's why we highly recommend that people have an elder law attorney in their stable early on, because people wait too long, and we spend most of our day correcting wrong advice and wrong practices, and it becomes a crisis.
I want to ask you a question that's not exactly on this list, but it touches on something you just mentioned. What is the biggest mistake that people make when it comes to planning and thinking about this?
There are so many. The biggest mistake we see, I believe, is not executing a durable power of attorney when somebody has capacity to do it. We're starting to do more and more guardianships in my practice, and it's really unfortunate because most of the people that we are doing guardianships for are individuals who are elderly and who were fine months earlier. And for a 90-year-old who needs to have a guardian appointed went 90 years without executing a durable power of attorney. In essence, they just got lucky, but their luck ran out, and now somebody must speak for them. It's hard. It's very difficult to admit somebody to an assisted living facility or skilled nursing facility without a guardianship. It's almost impossible to apply for Medicaid for somebody, because very often a Medicaid application requires some sort of a deed transfer or access to funds. And so the durable power of attorney, I think the lack of that, and it's such, out of everything that we do, it's literally probably the least expensive item in our list. It's so ridiculously simple. And I will say that you could potentially find one even online if you needed one. But a guardianship is going to cost $10,000, $15,000 by the time you're done with it. Months of heartache, and sometimes family disagreements. It's really just not worth it.
So you could avoid all of that or most of it with a durable power of attorney.
Exactly.
So get one.
Get one now.
Can Medicaid take your home?
No. So I'm glad you asked that question. Medicaid does not take your home. And I think that creates a lot of fear in people. That being said, the home is usually the individual's largest asset. So it is very important to protect the home. The home is an exempt asset when one is applying for Medicaid, so long as the applicant is living there, or the applicant's spouse is living there, or some certain family members are living there. So it's not counted for Medicaid purposes. However, we'd like to protect the home because sometimes when we have a married couple, things happen, and the healthy spouse may pass away, and the unhealthy spouse now may be in a nursing home, and now they have to sell the house, and now they have this large asset that they have to spend down. I think the reason that people think that Medicaid takes homes is something known as estate recovery. An estate recovery is the state's entitlement to seek compensation for the amount that they have paid for that individual's care. And very often, if somebody still has a home that they haven't transferred to their spouse, or they haven't sold yet and spent down those assets, if they are on Medicaid and they pass away owning that home, Medicaid will put a lien on the home. Medicaid doesn't want the home, but they will put a lien on the home for the amount they've spent on that individual's care.
Okay. You mentioned spending down assets. Are there strategies when it comes to Medicaid so that you don't have to spend down all of your assets to receive it?
Yes. The first thing we always do is we designate. Oh,
sorry, yep, there you go. You got it. Look at the camera.
The first thing, as far as spend down goes, the first thing we always do is designate what we're going to spend our money on, because there are certain things that individuals require before we use any higher level strategies. So if they're still living at home or their spouse is living at home, they can spend down on renovating the home. If they need a new roof, if they need boiler, kitchens, bathrooms, things like that, that's all allowable. They can pay down debt. They can purchase a car, which is for seniors, that's very uncomfortable, but it's a great strategy. So somebody is driving a 15-year-old car and their loved one goes into a nursing home. The last thing they're thinking about is buying a new luxury car, but they can do that. And I would recommend buying a pre-owned luxury car. And if you're uncomfortable driving that automobile, once your loved one is on Medicaid, you can actually sell it and recoup some of the money you spent on it. And they can prepay their burials, so things like that. But after all those spend down items are complete, then we go to a higher level strategy, which maybe we might use something known as a Medicaid compliant annuity. I think it's beyond the scope of this presentation or this interview, but that is available, where it's not a true spend down. It's actually a conversion of countable resources into an income stream for either the community spouse or for the individual applying for Medicaid.
Okay, let's talk about estate planning. Are there a certain number of essential documents that you have to have when it comes to estate planning?
Yeah, I would say the bare minimum. We provide what we call a will package, which is your last will and testament, your durable power of attorney, and your healthcare directive. Without those three, you're leaving holes in your planning. There's no reason not to have those items. We do a lot of planning for younger families as well. So without a last will and testament for a younger family, for instance, you can't designate who you want as a guardian for your young children. As an elderly couple, your last will and testament provides the ability to shelter more assets, because instead of leaving assets to one another as you get older, you may want to leave your assets either to a trust or to an adult child or adult children, in order for the surviving spouse to have less money to spend down for Medicaid purposes, but still protect what their spouse has left them. Okay.
What happens if, say I'm the adult child caregiver of my mom or dad or both of them? What if I can't get them to sign a power of attorney, or I don't get it done prior to something happening? What transpires after that?
Right. So if somebody refuses to sign a power of attorney, or it's just an oversight, interestingly enough, we do see a lot of seniors who have last wills and testaments, but they do not have powers of attorney. I can't imagine allowing somebody to leave your office without executing all of their documents. But I've had a handful of individuals who flat out just refused to sign durable powers of attorney. They're usually the patriarch of the family, who says, I'm not allowing anyone to do anything for me. My father died in his sleep. I'm going to die in my sleep. I'm going to be fine until the day I die. And those are usually the people who need it most. Yeah. So what happens if they haven't executed that durable power of attorney? As long as there's no need very often things are fine, but sometimes there's a need. For instance, I mentioned before, there may be a need to apply for Medicaid, or there may be a need to admit to a nursing home or an assisted living facility, or to move money, or something has to happen. So at that point, usually a family member is seeking a guardianship over their loved one. And the guardianship is a very involved process. It's very procedural, so long as nobody challenges it. But it is very often, even though it is procedural, and even though there may not be a challenge to it, it's the normal time frame is 8 to 12 weeks. And by the time you're done paying the attorney for the proposed guardian, the attorney for the fee for the court-appointed attorney, which everybody's entitled to representation, and then the fees for 2 doctors who must evaluate the individual, you're usually into this for $10,000 to $15,000. And as I said before, it's just totally unnecessary. A simple durable power of attorney would have sufficed.
So that was my next question. What is the guardianship process like? And you mentioned what it was like if there were no challenges and everything was sort of smooth sailing, if you will. How often are there challenges? And then how does that change things?
Well, luckily, we don't see a whole lot of that. If there are, I mean, it happens all the time. But if there are, then it's true litigation, and it can go on for a year, and tears families apart. So hopefully that won't happen. What we propose for people, what we recommend people do, is execute these durable powers of attorney when there's no question as to their capacity, where there's no question as to undue influence, and then they're choosing the individual that they want to act as their durable power of attorney. If they wait until they're incapacitated and there's a guardianship proceeding, then all of a sudden people start coming out of the woodwork. The Monday morning quarterback who lives in another state says, wait, my sister's not doing a good job, I'm going to do it. And that's where these challenges and litigation come in.
Now, what if your loved one has, let's say, dementia? Are they still able to sign estate planning documents, or how does that change things? Are they now it's all up in the air because they don't have the wherewithal to be able to make those sorts of decisions? What happens?
Right. So that's a great question, because many people come to us and say, my dad was diagnosed with dementia, so he can no longer sign documents. And very often a doctor will even say, this individual is incapable of making decisions, they shouldn't be signing estate planning documents. But the threshold is actually fairly low. So as long as the individual is lucid in the moment and understands what they're signing, approximately what their assets look like, and to whom they want to give their assets to, or who they want to make their agent, it's very often okay. It's touch and go, though, a lot of times. And there are times when we will meet with families multiple times to make sure that the individual signing is actually capable of signing that document at that point. But just being diagnosed with dementia certainly is not going to stymie the process. There's not going to be a reason for them not to sign just because of a diagnosis.
Got it. Okay. Now, what exactly is a certified elder law attorney? Are there certain criteria that go along with becoming certified?
Yes. So a certified elder law attorney has exhibited enhanced knowledge, skills, and proficiency to properly act as an elder law attorney. There are only, at last count, 500 certified elder law attorneys in the country. So we must be licensed, obviously, to practice law. We must have practiced for a certain period of time. 5 years right now is the criteria. They must have substantial involvement in the area of elder law. So that criteria at this point means 16 hours a week practicing elder law. Somebody like myself, I'd probably practice elder law 60 hours a week, but 16 hours is the amount. And they must have handled at least 60 elder law matters in the 3 years prior to applying to become a certified elder law attorney. They must continue to do continuing legal education. They must get peer references, and then they must pass a rigorous exam. The exam is a full day exam. It's comprised of multiple choice and essays. There's no review course like for the bar exam.
Mhm.
And at last count, there's a 50% passing rate.
Wow.
So it's tough.
What is the difference between a living will and a DNR?
So that is always a source of confusion for people. People shortcut the living will and say it's a DNR. My parents didn't sign a DNR. So a living will, which is signed in my offices by the individual, is it states, in the event that my death is imminent and that there's no hope of recovery, and depending upon the document, 1 or 2 doctors has confirmed that there's no hope of recovery, I'm in a vegetative state potentially, then I do not want to be kept alive by artificial means.
Okay.
So kept alive is really the active phrase here. Now, the DNR, or do not resuscitate, says in the event that I'm in cardiac arrest or suffering from a stroke, I do not want to be revived. So this is not about being kept alive, it's about being revived. So the way I like to explain it is, if somebody has signed a DNR or someone has not signed a DNR and they are revived, they have a heart attack and they are revived, now they're breathing, but they need to go on a breathing machine, a ventilator.
Mhm.
At that point, the living will would take control. If I cannot breathe on my own anymore, then I want you to remove me from artificial breathing apparatus.
Okay.
Okay.
Right.
So the DNR is, by the way, signed in the presence of a doctor. It's usually signed by the healthcare power of attorney if somebody is so ill that they can't sign it themselves, or that they But for instance, an individual who is in the late stages of cancer, but they are cognizant, may say, hey, if I have a heart attack, don't revive me, because that wouldn't make sense. I only have a few more weeks to live. So that's another good example of a DNR.
Okay. And you just mentioned the healthcare power of attorney. Is there a difference between a healthcare directive and a healthcare power of attorney?
Yeah, so there's a subtle distinction. In my office, we draft healthcare powers of attorney, which designates the healthcare representative who would admit you to a hospital or a nursing home or consent to a surgical procedure if you are unable to make those decisions. But they also are the individual that handles the living will. So the living will I do as a separate document. If they're combined, then it's called a healthcare directive.
Okay, got it. So I'm going to ask you now some general questions. The first one being, what's specific to elder care and elder law issues, topics, whatever, did we not touch on that you would like to talk about? Are there any?
I can't think of anything off the top of my head.
And that's okay. I mean, and you know what? I'll re-ask you that question at the end and see if anything's popped up, because I have a few more things I'd like to dive into. That's just sort of a broad overview of what you do, why you do it, who your team members are, that sort of thing. So,
I do have a question.
yeah.
That I want you to ask me.
Okay.
Which is, when is a good time to see an elder law attorney?
Okay. Eric, when is a good time to see an elder law attorney?
That's a great question, Kerry. I would say that if a married couple or an individual are healthy, then sometime in their mid-70s, they should be seeking the advice of an elder law attorney, just to make sure all of their ducks are in a row, make sure that if there is planning that needs to be done, that it's done. I can review their long-term care insurance policies if they were able to secure long-term care insurance early enough. But otherwise, when an individual is diagnosed with a long-term care chronic care need, such as Alzheimer's, any type of dementia, Parkinson's, multiple sclerosis, or very often people come to us when they're moving a loved one into an assisted living facility or a skilled nursing facility. I always like to make certain that people come to us before they're in crisis. And I said earlier that it's not in human nature to plan. And so people would rather, first of all, nobody wants to sit and talk to an attorney. So we try to make it as friendly and not intimidating as possible. But people should plan in advance. We do so much crisis work that it's refreshing when people are willing to plan.
Good answer. Good question. Tell me about NJ. No, tell me about NJELC. Tell me a little bit about your firm.
Okay. Hold on one second.
Okay.
Somebody's trying to. Okay. Okay. So New Jersey Elder Law Center is an extraordinarily unique law firm. I've always been fond of saying, I don't want our clients to look at us as a law firm. We're really providing a valuable service to them. And we attempt to treat our clients as family. So how do we do that? Well, the way that we've always managed the firm, Claudia Pergola and myself, is that we've always stated that if we treat our team with respect and compassion, and training, that is going to translate into treating our clients with respect, care, and compassion, and show how educated we are in this area of the law. So very often, while I'm always available to speak with our clients, they'll seek the opinion of another team member because they know that person has been doing the same thing over and over again. Also, the other thing is the way that law firms are very often structured is it's a top-down type of structure where everybody is nervous around the lead attorney, and the lead attorney takes priority over everything else. The way I look at things in business in general is that we all have a role to play. So I'm just another cog in this machinery. And whereas I'm doing certain things, Clellie is doing certain things. She has an area of expertise, which I don't know anything about. Jessica has an area of expertise I don't know anything about. Amy does. So we all act as one cohesive unit.
Why did you start NJELC? Did you see something? Did you see an area or a need that wasn't being served within that industry? What inspired you to start?
Well, I had training as an elder law attorney, and I had my own family experiences. But what I saw overwhelmingly was that there is a disconnect between the client and the law firm very often. And lawyers have a bad name, and unfortunately, I think it's for a reason. They don't communicate well. They're not compassionate, and they're not easy to talk to. Lawyers enjoy using very technical language, and unfortunately, whether they are intending it to or not, they tend to talk down to their clients. And I felt that if I could create a firm that is based in compassion, education, and process, that we could do incredible things for our clients. And knock on wood, so far it's proven correct.
Was it part of your family experiences that moved you into this particular arena? And do you feel comfortable talking about them?
Well, I will say that I got lucky. It wasn't that wasn't the impetus to move into elder law, but it was the aha moment. It was the epiphany. So my wife's grandparents moved up from Florida. They were becoming elderly, and he was having trouble walking, and she had the beginning stages of Parkinson's. And they moved in with my in-laws, who were in the midst of retiring. This is, as we all know, this is the last thing that somebody wants to, the last responsibility that somebody wants to take over when they've worked their entire lives themselves, have saved their money, and now they're ready to, I mean, for lack of a better word, to be selfish.
Mm-hmm.
And now these two individuals are living in their home, and they relied on me a little bit. They relied on my wife and the rest of the family all to come together and help my wife's grandparents. They lived in that house for almost 7 years. And then it got to the point where they ran out of money, and my in-laws just could not care for them anymore. We see this all the time. The police were being called all the time because there was a fall and nobody could help my wife's grandfather get up. And so they both ended up in a nursing home. My wife's grandmother died very quickly. She had Parkinson's, but my wife's grandfather, who had all of his mental capacities until literally the last week of his life, died at 99 in a nursing home, and he was miserable. And I was just starting elder law then. And when all this happened, I realized that there were so many things that we could have done differently. And nobody knew elder law attorneys existed. We didn't know. They had no idea this existed, this field. And once I found it, I said, wow, this is my calling. And I'm going to make sure people know that elder law attorneys exist, because we can really help families. And there's so much heartache and money wasted that, you need somebody to guide you.
You want to share a little bit about your team? Introduce potential clients to the people you have around you.
Okay. You want me to go through the team?
Sure. Yeah.
Okay.
We had a little extra time, so let's
Okay.
dive into when people are thinking about hiring you. Who will they be talking to, and why are they great at what they do?
Okay. So for the most part, when somebody calls NJELC, the first person they will talk to is Amy. Okay? So Amy Neely has a long history working in assisted living facilities and working with seniors, and she is a sweetheart. Almost every time a client gets on the phone with me, they say, just want you to know that Amy is a gem. She's the best. And so she does a lot of the calendaring. She schedules the first meeting, and she also takes care of a lot of the marketing and things like that. She usually at that point passes it off to Jessica. Jessica's been with us for 5 years. Jessica is the client case manager, and Jessica really operates the client experience. So she takes the client through all the various things and people that they're going to meet along this journey. And the first thing that Jessica does is she does an intake with the client or the client's family member to find out exactly what they need and whether we can help them. And she provides, between Jessica and Amy, I'm provided with all of these notes, and then the clients come to me for our first initial meeting, which is a complimentary meeting. It's usually an hour long. Tonisha Brooks does our estate administration. She does some Medicaid applications, but when people pass away, they need guidance. How do we distribute this estate? What do we do now? What's the next step in the process? And so Tony's been doing that. She's been with me for 11 years now. She's been practicing estate administration as a paralegal for about 15 years. Then we have Heather. Heather is actually the newest member of our team, and she's been with us for 2.5 years. And she does Medicaid applications, and she is incredible at it. She is so compassionate, and she creates these relationships with county caseworkers because she's so nice and accommodating that I feel that we're able to push the applications through the process a little faster than we've been able to in the past. And then there's Clelia. Clelia Pergola founded the firm with me. She's been here since day one. She runs the whole show. So she's not an attorney, but she acts as a managing partner. So she does literally everything that's not being done by somebody else. And Clelia, as you know, you've spoken to her a number of times. She's never not working. She's a wonderful mother, but Clelia can run a business off her cell phone.
Mm-hmm.
So, and we do a lot of team building exercises. We do some interesting management. We have an interesting management style, so that everybody feels that they're being treated like an equal and treated like we treat I like to say we treat our staff like they're adults, because they are. And as a matter of fact, I don't know if this is important to this. You can always take it out if it's not. Which we've tried an experiment, because our team is so close. We have unlimited vacation days.
Oh.
So, but as you well know, it doesn't matter how many vacation days someone gives you. You just can't take them anyway. So for us, we leave the decision up to them. You can take vacation or you can work, and it ends up that people appreciate that. But in the end, my staff's not going to abuse that privilege. That's for sure.
Yep, I love that. I have never worked for a place that has offered that, and I would quite enjoy it. Although I know I would do the same thing. I would end up not taking it.
Right.
One other, I guess, question for people who are thinking it may be time for me to look into an an elder care attorney.
Mm-hmm.
A couple of signs that it's time, and then what do they need to do? Do they call you? What's that process look like?
So the time is whether they're getting up there in age. I'd say 75 years or older, diagnosis of a dementia, Parkinson's, or MS, or just frailty. I like to say that there are young 75-year-olds who look like they're 50, and there are 75-year-olds who look like they're 90. Mm-hmm. And very often they don't have a chronic illness. They're just frail people. Maybe they didn't take care of themselves, or genetically. So some people are just frail, and that they're going to end up needing some care at some point. Or very often somebody who has always had some sort of a psychological issue, very often with some sort of mental illness. As they age, they also may need more and more help. So that's from the elder law perspective. Obviously, estate planning, people should always have estate planning documents. So the process is they call our number, 973-228-1795, and they often get Amy on the phone, and she takes them through the whole process. As I said before, we're very process driven, which makes our clients feel very comfortable. They're not complaining that they're not getting their emails returned, that phone calls aren't being returned, that how come it's taking 6 months to draft my documents? Everything has a timeline to it. And we're very proud of that, because, as one individual once said about us, around here, the trains always run on time.
There you go. That's nice. One last question. What is your, I'm going to use the business, your USP, your unique selling proposition? What is it that makes you different from all the other firms out there?
Well, look, when you hire somebody, you're expecting that you're hiring someone who is proficient at what they do. So I know that we're proficient at what we do. I think that what makes us unique is the way that we do it. So when somebody goes through our process, they always feel comfortable. They always feel like they are the only client. They feel like that we're going to get the job done. We're going to get it done in the time frame we need it to get done, in a friendly manner, and it's going to be done correctly. And unfortunately, that's unique.
It is. That was a great soundbite to end on. Is there anything else that you want to add? I'll circle back to that question one more time before we wrap. Is there anything else you want to add that we didn't talk about? Anything you want to touch on that wasn't mentioned? Anything that sort of popped into your head as we were busy talking?
No. I'm so intent on looking at this camera that I'm like not thinking about anything else.
Well, you were fabulous. So I'm going to stop the recording, and then I'll just give you a quick